Okay, we'll go ahead and get started. Thank you for coming. So this webinar today goes over the employment law update for 2021, which is the cases and laws that were passed last year that I think are most relevant to my clients and local businesses in our area. So we'll go through everything by subject matter. And for those of you who don't know me, my name is Jamie Bosua, and I am an employment lawyer at Kroloff and a shareholder here. And I represent employers in all areas of employment law, from developing policies and giving trainings to helping with disputes with employees and any administrative or civil complaints or actions that have been filed all the way through trial. So what I'm going to be doing today is giving information about updates that occurred last year so that you're on track for 2021, but I don't have the ability in this presentation to give any kind of specific legal advice to you because there isn't an opportunity to learn enough about your situation to do that. So we're going to start with a very hot topic, of course, the COVID-19 health and safety issues. So I pulled this down off of the state website today, covid19.ca.gov. And so these are the counties that currently have stay-at-home orders in place. I think Greater Sacramento was just lifted, and Northern California as well. But we are in the San Joaquin Valley with 0% ICU capacity, so we are still in a stay-at-home order situation. So under the current stay-at-home order, these are the following sectors that were required to close: indoor and outdoor playgrounds, indoor recreational facilities, hair salons and barber shops, personal care services, museums, zoos, aquariums, movie theaters, family entertainment centers, live audience sports and amusement parks. And the following sectors had additional modifications that allowed them to remain open, such as outdoor recreational facilities, retail and shopping centers, hotel and lodging, restaurants for takeout, pickup, or delivery only, offices open remotely, except for critical infrastructure where remote working isn't possible. Places of worship and political expression were to open outdoor only, and entertainments and sports to operate without live audiences. So those are our current stay in place orders. And then these are to remain open where remote option isn't possible. Critical infrastructure, schools that are already open for in-person learning, non-urgent medical and dental care, and childcare and pre-K. So those are the sectors that are open, and we'll see that as it evolves. For those that are allowed to open, the covid19.ca.gov website is the place to go to look for industry guidance for your particular industry on what's allowed and what isn't. And you could search by county and by industry in order to determine what can be open and what restrictions are in place for your particular business. I also want to go through briefly the isolation recommendations that are in place right now for California and the CDC. They're tracking together at this point in time. So the isolation precautions here are for someone who has either tested positive for COVID-19 or who has symptoms of COVID-19. So isolation would be for someone who is ill, and quarantine is for someone who has not yet been diagnosed with COVID-19, but was exposed. So these are the isolation recommendations. Isolation can generally be discontinued 10 days after symptom onset and resolution of fever without any medication, and with improvement of other symptoms. Those with a severe illness may need to isolate for longer, up to 20 days. So in that instance, you would be looking for the recommendation of your employee's healthcare provider to determine how long they should be out of your workplace. And if someone was exposed but not tested and has no symptoms, they should quarantine for 14 days. But we'll see that that has been reduced to 10 on the next page. I pulled this down off the CDC website. You see the link there. They haven't updated that bullet yet. A test-based strategy is not recommended except to discontinue isolation early. Retesting is not recommended at this point in time as well. For those that remain asymptomatic, I should say. So this is the December 14th, 2020 quarantine guidance from the California Department of Public Health. I have the link there on the bottom from where this is. So the California Department of Public Health is requiring that all asymptomatic close contacts discontinue quarantine after day 10 of the last exposure with or without testing. So this is for a quarantine. So this is not someone experiencing symptoms, but this is someone who had an exposure. So you count 10 days from the last exposure. There's also a shortened period for those that are working in an industry in which there's a critical staffing shortage and not enough staff providing patient care or essential critical infrastructure workers. So they are not prohibited from returning after day 7 from the last exposure if they've received a negative test collected after day 5. So this would include exposed and asymptomatic healthcare workers and exposed asymptomatic emergency response and social service workers who work. The exposed asymptomatic contacts are permitted to reduce the quarantine period to less than 14 days if they meet these following requirements. So wearing face coverings, staying 6 feet or more away from others, using a surgical face mask for those returning day 7, and continue face coverings through day 14, and then self-monitoring for any symptoms and isolating if symptoms develop. And these recommendations have changed over time over the past year pretty rapidly, but this is based on additional data. So I pulled this chart down from the CDC website, which shows charts post-quarantine transmission risk against the length of quarantine post-infection. So you can see that post-infection, once symptoms have abated, the risk of transmission goes down significantly. And so that's why these recommendations have changed. And I included this just because I thought it was an interesting chart to see what the data is showing now that there actually is data as opposed to last spring when we knew so little. So all employers are required to have an injury and illness prevention plan. And this has been the case for many, many years. The Department of Industrial Relations website, which I've linked to there, provides information on what should be in an injury and illness prevention plan and provides a template if you don't have one. I do help my clients with these. If you have any questions or concerns, you could consult with your attorney about that. And then you have to have a COVID-19 supplement. And the Cal OSHA actually issued a Word version of a COVID-19 safety plan that can be used to put one in place for your workplace if you don't have one already. They're very similar to the ones I was writing earlier in the year before they issued that, but slightly different and have some additional forms that could be useful. So you would want to check that out if you're working on that. So an illness and injury prevention plan requires every company in California to have one, or Cal OSHA and the law requires everyone to have one. And then you have to also train on these. So you have to train initially, and then when a new or unrecognized hazard is identified, and to allow supervisors to familiarize themselves with the hazard. And so when we had COVID evolve last year, that was a previously unrecognized hazard, which required training and an update to your plan. And as the pandemic progresses and expands and different things become available, like vaccines or other data or information, it's important to update that plan so that it's current and effective. So now jumping into, I want to go back and mention one more thing with regard to this quarantine and isolation requirements. A close contact for exposure is someone that has been within 6 feet of another person, an infected person, for 15 minutes or more over a 24-hour period. And people are determined to be infectious 48 hours prior to the onset of symptoms, or if they're asymptomatic, 48 hours prior to the positive test. So that's what you're looking at when determining whether an employee should be required to quarantine or isolate. Of course, someone who has COVID should isolate. Employees that may have been around them, however, for 15 minutes or more within 6 feet during the infectious period should be asked to quarantine based on those recommendations we just went through that were issued in December. Okay, so moving on, once you have a COVID-19 exposure, we had AB 685 last year that provided some notice requirements. So this was a law passed by the state legislature. Employers have to take the following actions within 1 business day of a positive confirmed case of COVID-19 in the workplace. You have to provide a written notice to all employees and employees of subcontracted employees who are at the work site within the infectious period who may have been exposed. So that's that 48-hour period before the onset of symptoms or the test result. You should consider whether you want to notify third parties like customers. You have to provide written notice also to employee representatives if you have a union. You have to provide written notice to employees and representatives of the benefits that employees could receive, such as workers' comp benefits, COVID leave benefits, paid leave, and the company's anti-discrimination, harassment, and retaliation policies. And you have to provide notice to the employees regarding the disinfection protocols you have in place and your safety plan. So this is quite a bit of information to pull together in 24 hours or 1 business day, I guess it is. And so I do recommend getting this prepared in advance so that you're able to do this. And I have been helping my clients with this, and it's just very stressful to have an exposure in your workplace and have to reach me and then get everything prepared and out within 1 business day. So doing it in advance, especially with the amount of spread we have right now, is a good idea and probably will make your life a little less stressful. The notice can be served by email or text if that's a reasonably anticipated way that the employee will receive it in 1 business day. This is really helpful. Employees not going to receive a letter by mail within 1 business day, obviously. And the notice should be in English and the language understood by the majority of your employees. So you have a majority Spanish-speaking employees, you should go ahead and translate that document. In addition to that law, which imposed notice requirements, Cal OSHA passed emergency rules that apply as well. So they require employers to report information to local public health agencies within 48 hours of learning of sufficient COVID-19 cases to constitute an outbreak. Right now at the state level, that's 3 cases. Oh, I don't remember off the top of my head. I thought I was going to say it correctly, but it's 3 cases, but I don't remember the size of the employer. But there's the link, outbreak definition and reporting, and it does change. So you don't want to rely just on what I'm saying in my presentation right here, but instead you want to check what is the current guidance. And local health authorities may have different requirements. San Joaquin County is following the state right now, but other jurisdictions, especially in the Bay Area, have different reporting requirements. So you'd want to check those if you had employees in other areas. The law removes the notice period for issuing a serious citation. This gives the employer less opportunity to contest that and give evidence to the investigator. So if Cal OSHA does an investigation, what's recommended is that you consult your counsel when you have an outbreak, when you have a case, and then if you have an inspector at your workplace, because you want to get them as much information as possible early in the process so that you can try and avoid a serious citation. If you have your IIPP in place, if you have your COVID supplement to that, and you're enforcing all of these regulations and safety protocols, that's how you avoid a serious citation. So you want to get that information to the investigator. I have a question here I'm just looking at real quick. Okay, the question is, in notifying staff of a positive result for a staff member, do you give the name of the staff member that's positive? And that is not permitted in California right now. So you just have to identify in your notice that an employee or an individual who we have reason to believe came into close contact with you has tested positive for COVID-19. Now, maybe you have a small workplace and everyone knows who it is. That's fine that you can't control that, but you can control what you put in writing and what you tell the other employees. So you just want to refer to that employee generically to protect their privacy, because they have a right to privacy in their medical and health condition and information. Okay. So piling on, that's what we do in California. So here we have Cal OSHA issued a temporary COVID-19 standard that became effective November 30th of 2020. It's what defines an outbreak as 3 or more cases in a 14-day period, and a serious outbreak being 20 or more cases within a 30-day period. Employers who have an exposure in their workplace have to follow these requirements. They have to offer pay for COVID testing during work hours. So you're paying for the time the employee is getting tested. Most employees do not incur an out-of-pocket cost for the test. It's being covered by the government and by their health insurance, but you would have to pay for that time. You have to exclude exposed employees from the workplace for 14 days and maintain their earnings and benefits. So that's actually 10 days. We'll see on the next slide, in line with the California Department of Public Health guidance. But this is what the current standard is. They didn't modify the law. So this maintaining the earnings and benefits can include supplemental earnings like paid time off, like FFCRA leave, or even disability benefits that someone might be receiving while they're out. So the employer may have to pay only a small amount to supplement the difference between that wage replacement and what the employee would have earned. And this applies for employees who were exposed to COVID in the workplace. So you're going to want to investigate the case and determine, does this apply to me, and document why it doesn't if you're not going to follow these requirements. You have to follow requirements for returning those who had a positive test, including the appropriate isolation period. And you can't require a negative COVID test as a condition of returning to work. And that's because a lot of people who recover from COVID continue to test positive, even when they're no longer contagious. So for that reason, to get people back to work, you want to follow the isolation protocols or the advice of the individual's doctor. And I have another question. During the 10 days off for isolation or quarantine, can they work from home? Yes, if the employee is not ill and they have the ability to telework, then you could just have them telework and you wouldn't be putting them on leave. You would just be paying them their regular salary for the work they are performing at home. For those that can telework, this really is very helpful. But for those that can't, that's when we're talking about the wage replacement. I'm reading another question. The question is, what if I find out on a Friday that employees tested positive? Notifying on Monday would be more than 24 hours. The requirement is 1 business day. I misspoke when I said 24 hours. So you do have 1 business day, so the weekend would not count. Okay. The governor then issued an executive order, piling on again. He suspended the Cal OSHA emergency temporary standard for quarantine to the extent it exceeds recommendations by the California Department of Public Health. They are recommending the 10-day quarantine. I have the link there again. And also, if you have a public health department that is recommending a longer quarantine, that would supersede this. So San Joaquin County has issued an updated order that is 10 days with 7 days for asymptomatic healthcare workers and a specimen collected after day 5. So here in San Joaquin County, we're okay, but there are other counties that have not updated their orders based on this new information. And so those, you would need to check that if you have employees in another county. I have another question. Is there any issue with having an employee take a second test if they were exposed and the first test was negative, but the test was given only 2 days after exposure? Can we ask for a retest to happen after 5 days past exposure date. Yes, this is a common problem that I see, which is that employees have an exposure and go and take a test the next day. And the data is not showing that that is going to test positive. That's not going to be an accurate test result. That's why the recommendation for healthcare workers is a specimen collected after day 5, because that's more of an average of when someone is going to actually test positive, because the virus has to build up in their body. So if you are not satisfied with the test your employee comes back with, you have the option to either ask them to retest pursuant to this guidance, or to go to their doctor and get a healthcare note releasing them to return back to work. And we see that a lot when employees have COVID-like symptoms but don't have COVID. They have a cough and they don't want to go get a COVID test. If your physician is willing to release you to return to work, then that's usually sufficient. It really depends on the circumstances, but most physicians, if someone comes in with a cough, or every physician I have encountered over the last year, is requiring a COVID test if someone has COVID symptoms. So they're going to end up with a COVID test before their physician will release them anyway. Okay, so that's it for my COVID section. We're going to move into more of the new laws and cases now on other sections. So if anyone has a COVID related question, now is the time to ask it. We are going to go through COVID leaves of absence, so don't worry about that. But if you have any questions about the safety rules or the Cal OSHA guidance, go ahead and let me know. Okay, then I'm going to move along. We're going on to leaves of absence. So the Families First Coronavirus Relief Act and AB 1867, which is California's COVID Sick Leave Act that was passed this fall, were in effect through December 31st. And both expired technically on December 31st. The FFCRA applied to employers with less than 500 employees, and the California Act applied to those with more than 500 employees. And it also provided additional requirements for healthcare providers who had been excluded from the FFCRA. The FFCRA technically expired, but the government extended the period of time through which people can use it. So I think I might have this on the next slide, but I'll skip it. So if someone had used their 80 hours of sick leave in 2020, there's no additional leave allotment that was given in December. However, if they only used 40, they have the option, or the employer has the option, to allow them to continue using that leave through March 31st. We'll go into that in a little more detail in a moment. It was part of the Consolidated Appropriations Act. And this is completely at the employer's election. So the employer does not have to provide any additional leave under the FFCRA extension, but they can let people use any leave that is remaining through March 31st, and it extends the tax credits for doing that. And the California law was not extended, or hasn't been yet. And so if someone began using the leave prior to December, so if I developed COVID on December 27th, I can use the full amount of the leave under the guidance that has been issued by California. But I'm not entitled to start a new COVID leave under the California COVID sick leave law if I develop COVID on January 2nd. It's a little bit strange, but that's the way it works. Here's a question. If someone used all 80 hours of FFCRA sick and is using the expanded FMLA, are they still eligible for pay? And the answer would be no. If it's the 80 hours of sick, that was not expanded. So if they've used the total 80 hours, they've used up their full entitlement. It would only be if they had hours left over. If they'd used 40 in 2020, they could still use, at your election, 40 in 2021 through March 31st. So this is what it provided, just briefly, if you're going to continue using it. And the Biden administration is indicating that it's wanting to extend FFCRA through September of 2021. So I think it's valuable to go over this. So it provides, the FFCRA provided emergency paid sick leave, 2 weeks up to 80 hours for an employee quarantined or experiencing COVID-19 symptoms and seeking a medical diagnosis. So this isn't someone who has allergies. It's a COVID symptom, yes, to cough, but they don't think it's COVID. They don't go get a COVID test. That doesn't cover them. It also, and that's at their regular rate of pay, up to $511 per day. That's the cap. And that's reimbursable out of your payroll tax. Also, the emergency paid sick leave pays 2/3 of an employee's regular pay for 2 weeks, 80 hours, for caring for an individual subject to quarantine or whose school or daycare is closed. And the guidance from the Department of Labor is that they consider a school or daycare to be closed when the facility itself is closed. So if the school is only distance learning, that is a school that is closed. Expanded family medical leave is the second part of this act. It's 12 weeks, 2 of which are unpaid. However, you can overlap these for a total of 12 paid weeks. This 12 weeks applies for those who are caring for a child whose school or child care provider is closed. It's paid at 2/3 of the employee's regular rate of pay. The employee has to have worked 30 days for this portion. And the first 2 weeks would be unpaid unless they use the EPSL portion that we just mentioned above. These are the qualifying situations. This is the way they are described on the Department of Labor website. So I included this for you here. Someone who is subject to federal, state, or local quarantine or isolation, someone who has been advised by a healthcare provider to self-quarantine, someone who's experiencing COVID-19 symptoms and seeking a diagnosis, someone who's caring for an individual subject to an order in 1 or 2, someone who's caring for a child whose school is closed, or a substantially similar situation specified by the Secretary of Health and Human Services, which did not happen. So number 6 does not apply. Okay, I got a question here about whether the 80 hours has to be consecutive. So the 80 hours can be intermittent if the employee is using it to care for a family member or someone who has a school that's closed. And that's because there's no risk of transmission. So someone could use the hours, if school is closed 2 days a week, they could use 2 days a week at a time until they hit the 80 hours. If they're using it for their own health condition, however, they're contagious and they're required to be isolated and quarantined anyway. So someone who's using it for their own illness would have to use it consecutively. And remember, at this point in time, extending this and allowing employees to continue to use it is at the employer's election. However, I do recommend that if you're going to extend it, you extend it consistently across your workplace in the same way you used it in 2020 to avoid any claims of disparate treatment or discrimination against certain employees. And we'll see in a few days what the Biden administration does. I anticipate this is going to change. Okay, also, I want to note that there are several cities that have supplemental paid sick leave laws requiring additional sick leave. Long Beach, Los Angeles, San Mateo, San Jose, Sacramento, and San Francisco. So if you have employees in these cities, you want to check that out, see if you qualify or not. Some of these are very large. San Jose's is smaller. And make sure that you're providing whatever paid sick leave is required by those local ordinances. Also, I want to remind you all that if you have 25 or more employees, you're required to provide up to 40 hours of leave per calendar year for school-related emergencies, including school closures. So even if an employee has exhausted FFCRA potentially, depending on the reason, they might also qualify for this. So you want to be aware of this when you're evaluating what kind of leave is available to your employees. You can require them to use vacation or PTO, but you can't require that they use their paid sick leave, although they can if they want to. And so you just want to track this differently because each law requires a different application of paid leave benefits. So FFCRA does not allow you to require someone to draw down their vacation at the same time. So if you are applying FFCRA leave, you couldn't require that, even though the California School and Child Care leave requires that. However, if they are eligible for California School and Child Care leave separately after FFCRA is done, then you could require them to use their vacation. Also, I get this question a lot. They're out of FFCRA leave, they are out ill, or they're caring for someone who is ill. What wage replacement benefits are available? So of course there would be available any government employer paid sick leave, vacation, sick time. Disability insurance is also available if the employee is unable to work due to their own illness. Paid family leave is available for employees who are caring for other family members. Unemployment insurance is available for those who have lost their jobs or have had their hours reduced. You can get a partial wage replacement there. Pandemic unemployment assistance provides unemployment type benefits for independent contractors, small business owners. California paid sick leave is part of your sick leave program and would be available to an employee. There is a supplemental paid sick leave for food service workers, which applies to employers of 500 or more employees in the US. And then we have the FFCRA, of course, which we just went over, local governments, and then also workers' compensation. So there's a requirement to report to workers' compensation, and there is a presumption that has now been adopted into law that the illness was, or that COVID was contracted in the workplace. And so you want to gather your evidence if that's not the case. But someone would be eligible for workers' compensation benefits if they are ill and out of work because they caught COVID in the workplace. So that's it for COVID type leaves, FFCRA leaves. If you want to ask me a question about that, now would be the time. Otherwise, I'm going to move into the expansion of the California Family Rights Act. Okay, great. So the California Family Rights Act was expanded this year. It used to apply to employers with 50 or more employees. It now applies to employers with 5 or more employees. There used to be a geographical restriction, so employees had to work within 75 miles of a work site with a certain number of employees. That has been eliminated. The definition of family member was expanded. Now it includes siblings, grandparents, grandchildren, and domestic partners, in addition to spouse, children, parent, and that's it. It also deletes this provision that we used to have in the law where if you had 2 parents working for the same employer, you only had to provide 12 weeks and they had to fight out who got which weeks. That's been eliminated. And the provision allowing employers to refuse reinstatement for a top earner has also been eliminated. So for those of you who have 50 employees and already have a CFRA policy in your handbook, it still does need to be updated this year. So if you haven't already updated your handbook, I recommend that you do that. And also for those of you with less than 50 employees, but more than 5, this applies to you now. So my recommendation is to update your handbook, to create a policy, to implement it, and to understand how it works. And CFRA would apply for COVID potentially if an employee is ill or they're caring for someone who's ill. So the employee, it provides 12 weeks of unpaid leave for an employee's serious health condition, which would be an illness, injury, impairment, or physical or mental condition that involves inpatient care or continuing treatment by a healthcare provider. It's typically more than 3 days of incapacity qualifies with follow-up care. It doesn't include pregnancy or childbirth related conditions because in California, we have a separate law, the pregnancy disability leave law, that covers that. And that applies to employers with 5 or more also. People can take this 12-week leave also for the serious health condition of a family member, for the birth of a child and to care for that child after the birth, or for the placement of a child with an employee for adoption or foster care. Also, a qualifying exigency arising out of the fact that an employee's family member is on active duty in the armed forces, and to care for an injured service member during rehabilitation. So Employees are not automatically eligible for this. They have to have been employed with you for at least 12 months on the date they are requesting to begin the leave. And that's not necessarily 12 months consecutively or 12 months immediately preceding the request for the leave. It's 12 months during the previous 7 years. So if someone left and came back, they might still qualify. Also, that person has to have worked at least 1,250 hours during the 12-month period immediately preceding the commencement of the leave. And that is typically hours worked. So paid time off or an absence of some kind would not be counted in that service category. So this is about 2/3 time, I think. So you count back from the day the leave is supposed to start. The only exception for that is pregnancy. If an employee takes pregnancy leave under the Pregnancy Disability Leave Law, and then they want to use CFRA for the birth of the child and the baby bonding, you count their 1,250 hours from the start of their disability leave, which makes sense because the two are related. And that's how they overlap. So for those of you who I did your employee handbooks last year, I have also put together a checklist and some forms that you can use in trying to implement this law. So if I did your handbook and didn't send you that, let me know. Or if you want your handbook done, go ahead and reach out to me also. Now is a really good time to update because there was this very significant change. I just want to mention that the Families First Coronavirus Relief Act, if you're voluntarily continuing to use it, or if it ends up being extended by this administration, may or may not overlap with CFRA leave. So a school closure potentially would not be covered by CFRA leave, for example. So when you are evaluating, what you want to do is look at the total number of leaves available and then tick down which ones are applying at any particular point in time. Make sure you're complying with the restrictions of each one. So CFRA leave, California Family Rights Act leave, this new expansion, this provides job protection, but it's an unpaid leave. So the employee can elect to use their vacation, their PTO, their sick leave for this. But they can also, if they don't have sufficient time, they can just take it unpaid. And also they could apply for some state benefits during the time they're off, like disability or paid family leave. So going into some of the cases relating to leaves of absence this year, Glynn versus Superior Court was a pharmaceutical sales rep who took a medical leave of absence for a serious eye condition that was causing some blindness. He applied for an alternate position, but it wasn't given to him for whatever reason, I'm not sure. And then 6 months after his leave began, he was fired. And that's because an employee in the HR department, actually a temp, erroneously made the decision or the determination that he was no longer eligible to remain on inactive status. And the employer argued that there was no discriminatory animus because it was a mistake. And the court held that a lack of animus does not preclude liability for a disability discrimination claim in a leave of absence situation such as this. So you really want to make sure that you are terminating employees correctly who are on a leave of absence or who are requesting a leave of absence. This is a very high liability area, is terminations relating to leaves of absence or requests for leaves of absence. And a lot of the COVID litigation that we've seen is for failure to properly grant leaves or disability accommodations. So that's where we're seeing the liability here. Okay, moving on to the area of independent contractors, if there aren't any questions about the last section relating to leaves of absence. Okay, great. Okay, so we had AB 2257 this year, which was modifications to AB 5. And AB 5 is the ABC test for independent contractors, very well known, I think, especially with Uber and Lyft putting their ballot measure on. Now that ballot measure only affected app-based drivers and delivery services. So there is a misperception that I've seen that, oh, that passed, so now everyone gets to be an independent contractor. That's not the case. The law has specified exemptions in it, and then the ballot measure and the proposition only applied to app-based drivers and delivery services. So the business-to-business exemption is the first expansion that we see in this bill, and it expanded the opportunity to exempt businesses who are contracting with other small businesses to also public agencies or quasi-public corporations for retaining a contractor. So that's great for those public and quasi-public corporations. Now, just and AB5. Just because you have an exemption in AB5 does not mean that someone is automatically an independent contractor. What that means is instead of applying the 3 factors under ABC test, you apply the common law test. And I believe there was a subtract as well. So even with these exemptions, this is a touchy law that is rapidly evolving. Which created exception from AB 5 for situations in which individual business persons contract for providing services at the location of a single engagement event. There's a referral agency exemption that came into law this year, expanding the exemption for consulting, youth sports coaching, caddying, wedding or event planning, wedding and event vendors, and interpreting services. The professional services exemption was expanded to add contributors, advisors, producers, narrators, and cartographers. It added specialized performers who teach a class for no more than a week, appraisers, registered professional foresters, and home inspectors. And then there was some restrictions on the number of publications journalists had to submit to meet the exemption, and that has been modified and eliminated. Also, we saw a lot of expansion for exemption for music industry and performers. Recording artists, songwriters, lyricists, I've got the list here if this applies to you. Musicians and musical groups engaged for single engagement live performance events. Also, individual performance artists are exempt. So these exemptions have expanded. Also, manufactured housing salespersons, individuals engaged by international exchange visitor programs, amateur umpires and referees, and competition judges. So it's just all over the map at this point in terms of who is exempt from AB 5 and who isn't. And now we have the Dynamex, the case that just came down yesterday, which makes Dynamex retroactive. So if my recommendation to those of you running businesses is to pull your 1099s from last year and to evaluate who you paid as an independent contractor and whether they should have been classified as an independent contractor and whether you have the documentation you need for them to be classified as an independent contractor, because there is a lot of risk and a lot of penalties associated with failing to pay someone as an employee if they shouldn't have been classified as an independent contractor. And that is primarily because the state wants its payroll taxes and the federal government wants its payroll taxes. So there's liability arising from those taxes that are due for those who have misclassified someone. I have a question I'm just going to look at here briefly. So the question is, we have a company policy that is a nationwide policy that leaves after 12 months will end employment. Is that okay to do in California? So in California, I do not recommend having a blanket policy that fixes a termination date. In California, that's because if someone is out because of their own health condition, once the protected leave ends, the employee then comes under the Americans with Disabilities Act and the Fair Employment and Housing Act, which requires a disability accommodation if one is available, and an interactive process to determine what that might be. So rather than terminating employment at a specified time period, it's best to meet with the employee to figure out what accommodation may or may not be available, to engage in that interactive process, and then make an individualized determination about whether that person needs to be terminated at that point in time. Does a cleaning service who comes in daily to clean the office qualify as an independent contractor? So under AB 5, they have to meet 3-part test for that. If they are providing, the third part is that they are providing the service for others. So if they are cleaning multiple offices, then that component would be met and they would probably be an independent contractor. There's other factors that you would look at. It's hard for me just to give an answer across the board, but the more they look like an independent business providing that service to multiple people, the more likely they are to be an independent contractor under any of the tests. Okay, I am going to move on to wage and hour, which is the area where we see the most cases and the most litigation right now. So one thing to note, I won't spend too much time on this, but the minimum wage went up again, and it will increase to, or did increase now that we're in January, to $14 per hour for those with 26 or more employees and $13 per hour for those with 25 or fewer. If you are on the cusp of 25 or 26 employees, there is a specific way in the law that you count, and it includes some people that may not be on your permanent payroll. So just be aware of that and look into that if that applies to you. Also, I always like to remember that there are salary thresholds for certain types of employees. Oh, and there's a typo. Sorry about that. Why didn't the spell check catch it? Oh, but they're listed here for you. And several typos. I can't type well. So they're listed here for you. And just remember that if your exempt employee no longer meets the salary threshold, their salary either needs to increase or they need to become an hourly employee. Also, there's about 20 something municipalities that increase their minimum wage this year as well. So if you are operating in a city with a minimum wage ordinance, it is a good idea to check that and make sure that you're paying the minimum wage for that city. So we had a case, well, we've been having a series of cases, quite a few cases recently on de minimis time. So Frecklin versus Apple Inc. was a case involving Apple Store employees who were subject to bag searches before they left for the day. So they would clock out, then they would have to hunt up a security guard, potentially wait in line, sometimes for quite a while, 20 to 45 minutes, I think the case said, and then they were allowed to leave. And the question brought before the court was, is this compensable time? Should they have been paid for that time that they were standing there waiting for their bag to be checked? And the court said yes, the employees should have been paid because they were subject to the employer's control during that period for two reasons. Apple made employees find and flag down a security guard to conduct the search and then confined the employees to the premises during the search. So they couldn't leave and come back for their bag to be searched. Obviously, that wouldn't make any sense. And then two is that although the bag search wasn't required because the employees could choose not to bring a bag, as a practical matter, the search was required. Employees all brought personal belongings to work, and as Apple Store employees, they brought their iPhones to work. So that required the search. So the search was essentially required for all employees. So the takeaway from this is if you have your employees required to do something either before they clock in or after they clock out, you want to be aware of that. You want to assess whether that's happening, and you want to do everything you can to capture all of that time in your timekeeping system. So if Apple had put the clock out after the exit search, these people would have been paid for this time. That would have solved the problem in this case. Meal and rest periods are always an issue. In David versus Queen of the Valley Medical Center, the employee argued that she had been denied her meal breaks. You want to make sure that your meal break policy, you're all updating your handbook anyway because of the CFRA expansion. So go ahead and make sure that your meal and rest break policies are compliant as well. So this employee argued that because her supervisor had walked into the break room, looked at the clock, looked at her and walked out, that she had been pressured not to take her full breaks. Court said that's not enough. So that's helpful to employers. Also, coworkers who would come in and interrupt her break and ask her a question, but supervisors had no knowledge of that and weren't instructed to do it. That's also insufficient. And further, an instruction not to work overtime is not enough to count as an instruction to perform work off the clock. Also, one note that I always like to make when we're talking about meal and rest periods is if your employees are taking on-duty meal periods, first, they need a written waiver for that. Second, you have to make sure that those on-duty meal periods are also 30 minutes long. This case involved travel time, Oliver versus Konica Minolta Bus Solutions. So in this case, employees drove their personal vehicle from home to the first customer site. Normally, of course, that's not compensable. You don't start paying someone until they actually get to work. But these employees were carrying employer tools and parts, and there were restrictions on where they could go in the car when those tools and parts were in the car. So in this case, the case was allowed to proceed, and more evidence was going to be submitted regarding whether they were subject to the employer's control during their commute. So if you have employees commuting with your tools where you place restrictions on the use of that vehicle, that's just something to look at and see whether you want to update your policy. We had a case on unlimited vacation time. A lot of companies have unlimited vacation time for their higher level employees, their exempt employees. And in this case, this employee sought a vacation payout after she left the company, even though she had an unlimited vacation policy. And the fault here with the employer was that wasn't in writing. It wasn't conveyed clearly to her. The handbook only applied to hourly employees. So there was nothing in writing pertaining to this exempt employee who had unlimited vacation. So the court gave us some guidance on what an unlimited time off policy should include. It should be in writing. It should clearly provide that time off is not additional wages, but instead is part of a flexible work schedule. If people are not taking time off at all, that should be addressed. And employees need sufficient opportunities to actually take some time off, and it can't be a use it or lose it policy. And in that instance, you don't have to pay it out upon termination. Herrera versus Zoomies Inc. Was a reporting time pay case. Employees were required to call in prior to their shift, and they claimed that they were entitled to reporting time pay, and the court agreed. So these employees had to make themselves available to work during that shift time. Then they called their manager 30 to 60 minutes before the shift and were told whether or not they had to work. So this triggered the obligation to pay reporting time pay if they weren't actually required to work that day, because they had to set aside this time to find childcare, to be available, to be within reach of the employer during that period of time. This would have been a different case if this was an optional call-in. And so this is just something to be aware of. If you have call-in shifts, make sure you're paying them appropriately, and check that in your handbook this year as well. Ridgeway versus Walmart was a trucking case. Truckers alleged that they should have been paid for layovers, rest breaks, and inspections. And the big takeaway from this, the new thing this year, is that the layovers were found to be compensable because of the amount of control Walmart was exercising over the drivers during their layovers. So they couldn't travel freely, they couldn't avail themselves of the full privileges of a break, and so Walmart should have been paying for that time. So this is a reminder for trucking companies who have layovers. It's also a reminder just for all of us that if we're exerting control over the employees in California, that's probably going to be paid time. If you have 100 or more employees, SB 793 requires you to submit a pay data report to the Department of Fair Employment and Housing. I've got listed here the types of information that has to be submitted. That has to be submitted March 31st, 2021, and then each year thereafter. This is an attempt to enforce pay equity laws, which have been passed in recent years and reinforced. Okay, human resources and workplace policies. We had a change to employment settlement agreements. It was a year or two ago that employment settlement agreements could no longer include a no rehire provision unless the employee had been accused of sexual harassment or other wrongdoing in the workplace of that type. Now this has been extended to include criminal conduct. So you can include a no rehire provision if the employee was found to have committed criminal conduct during their employee or sexual harassment during their employment. Now, this has to have been discovered during their employment, however. So this just reminds us to make sure our settlement agreements are accurate for those of us who are attorneys. And it also reminds us that it is important to do your investigations timely and to stay on top of any potential employee misconduct timely, so that you can potentially include a no rehire provision in a settlement agreement. Also, AB 1963 expanded the list of mandated child abuse reporters to include human resources employees if the business employs minors. That also comes with an obligation to provide safety training and training on the reporting. So if you employ minors, your HR person will need to be aware of this. Discrimination, harassment, and retaliation. One of the big updates this year was that employers with 5 or more employees must now provide harassment training to all employees, 2 hours for supervisors and 1 hour for non-supervisors. And then this has to occur either within 6 months of hire or within 6 months of a promotion to a supervisory position. They have to receive the 2-hour training. I provided quite a few trainings at the end of this year. If you have not done this, I can do a Zoom training for you, or there are online options for the training as well. The DLSC has a free one, but I've gotten some complaints that it's not technically super easy to use, that it's frozen up, and it's a bit tedious. You have to click a lot, apparently. So that option is available as well, though, and would satisfy this requirement. AB 1947 extended the period to file a claim for laws enforced by the Labor Commissioner. So this would be like 98.6, retaliation for making a claim under the Labor Code provisions, or 1102.5, retaliation for making a claim of a violation of law. So that statute of limitations has been extended. However, to file that claim with the DLSC is not mandatory. An employee could just move on to court if they want it anyway. This involves Title VII. California has for many years protected gay and transgender rights. That has now been extended under Title VII, under Bostock versus Clayton County, to federal law. After acquired evidence in Anthony versus Trax International, the employer's requirement pursuant to their government contract was that all of their technical writers have a bachelor's degree. And this employee brought an ADA claim, and the employer defended this case by arguing that he wasn't a qualified individual because he didn't have the degree required. He'd lied on his application. They hadn't realized this early. They realized it as the litigation commenced, but the court said, yes, this is a valid reason to defeat the ADA claim. He wasn't qualified. Now, this is important for a couple reasons. One, we do recommend doing background checks. They should have found this out earlier, then they wouldn't have had this employee at all and wouldn't have the lawsuit. Not good to hire employees that are lying on their applications for many reasons. It's a red flag. And secondly, it is important to look for after acquired evidence when defending a case so that you can use that in the litigation. So you want to look at the employee's computer, look into whether their credentials were valid, whether they lied on their application. Pay equity. This was a case, Rizzo versus Jovino. Prior pay is not a defense to a pay equity claim. The court said that prior pay is not enough for the affirmative defense of any other factor other than sex. So there has to be a job-related factor relating to the current employment. So when evaluating whether your salaries are equitable across all of your employees, location, amount of education, amount of responsibility, all of those things would, years of experience, those are all job related. What the person was paid previously is not. I have a question here about FFCRA. FFCRA did not get renewed, but it allows the employer to get tax credits until March 31st. Do employers need to do anything to get the tax credit, or is it automatically extended without further action? My understanding is that it is automatically extended. If you're using a payroll company like ADP, for example, you would, I think, follow the same process you were following before to check the correct box for why that person is on leave, and they automatically take care of deducting that from your tax liability. There is a process for seeking the tax reimbursement if you're not using a payroll company. If you want to email me, I can get you that information. There's a frequently asked questions on the IRS website that goes through the steps for that. This is the last section here, is that the California Consumer Privacy Act was expanded this year. My colleagues Allison Lafferty and Courtney Hayes did a presentation on this last Friday. It will be up on our website if you want to learn more about this and determine whether it applies to you and what all of the changes were. For the purposes of employment, however, what's important is that employers are currently required to provide notice at or before collection of personal information of employees, applicants, or independent contractors about what information is being collected and what it will be used for. The COVID-19 pandemic required some employers who are subject to this law to provide additional supplemental notices because they started collecting new information like temperatures and where people had traveled to and who, if they had come into contact with someone with COVID. So that's all personal information that is covered by this act. So if you're covered by the California Consumer Privacy Act, do be aware of that. The other obligations that we talked about last year that were going to come into play have been extended for another year. So this is really what businesses need to be worried about right now, is providing notice and then implementing appropriate security measures also. Okay, so we have reached the end of the update. I have another question here. I'll hang around a few minutes and answer some additional questions if you have them. Also, if you would like a copy of the slides, please send me an email and I will send you a copy. If you are an attorney who would like to receive MCLE credit, please send me an email with your bar number and I will get you the materials for the MCLE credit and also send you a copy of the slides. Also, for those of you who are attorneys, I have a handout on the laws that I can provide you. I haven't yet finished putting together my handout for the cases, but I will be doing that in the next week. And I can also send you that. I'm also presenting a similar presentation to this for the San Joaquin County Bar Association, and those handouts will be provided as part of that presentation. Okay, I have a question here. After hiring a person a couple of weeks, oh, this is a pregnancy related question. Is failure to disclose a pregnancy something that they can be fired for? Typically, no. Employees do not have an obligation to disclose that kind of private health information. And so the pregnancy is one of the areas where I do recommend that you seek legal help because it is an area fraught with multiple overlapping laws and requirements and a lot of liability. So pregnancy is particularly complicated. Are there any other questions? Let me check the chat. Nope. Okay. Okay, well, thank you all for attending. Happy New Year. Hopefully, this was helpful to you and giving you an update on what you need to know for 2021. Again, go ahead and get your handbooks updated on the topics that we talked about. If you want help updating your handbook or in creating any policies that we talked about today, please feel free to reach out to me. And I wish you the best of luck and a great new year. Thank you.